So let me begin by talking a little bit about, the background of our paper, et cetera. So the paper came out of a symposium that Professor Sun and I put together. The symposium was originally scheduled to take place in Hong Kong, at the University of Hong Kong, where Professor Sun is based. However, the disease vector made it impossible for us to convene. And obviously regulatory rules in Hong Kong also made it possible for us to convene. I think Hong Kong is still following a zero COVID policy. And so there wasn't the ability for us to get together, though we convened virtually a year ago, right over the holiday break, in fact, very much as we are meeting now. Luckily, this meant that we didn't have to fly overnight to get anywhere, but it did mean that we missed out on the great Hong Kong food that Haochen would have taken us to. But the paper that is really trying to grapple with the kind of take a historical view of digital sovereignty and also understand where we're at. So kind of a big picture of where digital sovereignty it has been and is going. And in the process, I think Haochen and I learned a lot about this. I was actually surprised, and I'll tell you a little bit about that later, about what we found. And so then the question was, how do we frame all these kind of disparate findings about digital sovereignty efforts in place A or place jurisdiction B? What we ultimately decided was that digital sovereignty was both necessary and dangerous. And so, which leaves us in a kind of an uncomfortable position. It's really critical in order for countries to be able to regulate what's happening, because so much of what's happening is on the internet or internet mediated in some way. But it's also dangerous because regulating the internet gives a country power that it never before had. And so that double-edged sword, that double-sided coin of digital sovereignty is what we wanted to point to. The paper doesn't have any solutions to this problem. Haochen and I are working on these issues, as are lots of people. But it's and so we have another project in the works for a year from now. But trying to kind of articulate more solutions. But really, it's designed to kind of give us a historical view of digital sovereignty, and also to understand the complications of digital sovereignty today. I want to begin with a poll. So let me share my screen here. Okay, so I'm going to launch this poll in a second. So the question I want to ask you is, which country's laws does this provision come from? So you see a provision before you, and unfortunately I can't read it because my poll is obscuring this. Okay. You can read the provision yourself. I can't read it, unfortunately, because I can't. The poll makes it impossible to read. But
Article 7. I can jump and read it.
Yes.
Article 7. Provide users with options that are not based on their user profiles, or provide users with a convenient option to turn off algorithm recommendation services.
Okay, so I want you to try to tell me, is that from China's laws, India's laws, French laws, German laws, or American laws? And so we have two polls. Ignore the first question that I'm going to ask, choice 1, choice 2. Go with choice, only answer choice, the question 2. Okay. Okay. So the results are shared. Okay. So I won't tell you. Well, let me tell you that the majority views are incorrect. But the one thing that's okay. So the majority views are incorrect. I will not tell you right now what the right answer is, because I'm going to ask a number of poll questions. Okay. Oh, sorry. Okay. You see those results, I believe. Okay. So I'm going to stop sharing the results. I'm going to move the poll to the side so I can actually see it. Now I'm going to share my screen again. Okay. And now the second poll question.
I will read it.
Yes, thank you, Haochen.
So the provision says that to enable the receipt of requests for information from the country's law enforcement authorities, a person in the country shall be named who is authorized to receive such requests. The person so authorized shall be obliged to respond to such requests for information pursuant to the first sentence within 48 hours of receipt.
Okay, and I'm going to relaunch the poll. Relaunch the poll. Ignore the first question again. Okay, let's end the poll here and share the results. So here you do recognize NetsDG. At least 29% of you recognize NetsDG. And so, but of course that has been law, I think it's been in effect since 2018, passed in 2017, I believe. Okay. But the majority of you did not identify the correct country, but the plurality of you did. So kudos. I'm not sure I would have passed any of these, so don't worry. This is not a criticism of any of the audience. If you got it wrong, it doesn't mean you're not brilliant and know the internet world remarkably well. Okay, I could keep going on and on. And I think we'd come to the same conclusion, that the majority would get it wrong. Again, it's not because of your own failings, but So what are the answers? So let's go back. Let me go back here to the previous one. Provide users with options to turn off algorithmic recommendations services. That's China. In a new law, in a new regulation that was just approved at the last day of 2021. The regulatory authorities work on Christmas, on New Year's Eve, apparently, which I don't approve of generally. So that certainly would not have happened if I told you what day it was passed. I think we'd know that it was not Germany or France pretty readily. I don't know about India, and it certainly would not have been the USA either. Okay, and this is, of course, the German law, NetzDG, with this with a requirement that you have someone to receive service from in Germany itself. This has been described by some in the civil society as a kind of hostage-taking law. Service is not the same thing. So, is the service person going to be jailed for this, for your failure to act upon a demand, a law enforcement demand in the country? I think those are interesting questions. Anyway, I could keep on going. There's a bunch of these that I would have asked, but I don't think I have time to do that. But the point is that there's a lot going on in the world that if we had written it in a different language, we might think this belongs to this belongs to the laws of an authoritarian state or a liberal democratic state, and it might come from the opposite governance system. And no one chose China for that first provision that I suggested, the option to turn off recommendations as algorithms. Okay, let me turn back to Haochen to tell us about the origins. So when I'm supposed to talk about defining digital sovereignty and data sovereignty, we just use the broader term digital sovereignty, but I think I'm going to, in the interest of time, turn it over to Haochen to continue.
Thank you, Anupam. So could you please scroll down one page?
Yes.
Yeah. Yes. Okay. So the concept of digital sovereignty actually was kind of, first developed in China. For example, back in 2010, the Chinese State Council officially declared its support for the so-called internet sovereignty. In Chinese, it's called 网络主权, okay, internet sovereignty, in a white paper entitled The Internet in China. So the white paper declared that within Chinese territory, the internet is under the jurisdiction of Chinese sovereignty. And later on, the China's cybersecurity law further, strengthens this idea. So this cybersecurity law was passed in 2017, and Article 37 of the cybersecurity law requires that data and personal information originating in China should be stored within China. So this is absolutely a very strict data localization requirement. And the article also requires that critical information infrastructure operators must also undergo security assessments before the data can be transferred abroad. So the law manifests China's sovereignty in controlling cross-border flow of information. And later on, there's a, the incident occurred sometime. There's something going on, I think, in the background. Yeah. Anyway, I just keep going. I'm pretty sure that the audience have heard about, Ant Financial Service Company. It's planned to went public to got it listed in Hong Kong Stock Exchange. But before, it was about to be listed, the Chinese government actually ordered the company to stop this plan. So overnight, this listing plan was terminated. And this incident was another example of China's exercising its digital sovereignty. And so China has been sort of accused for breaking cybersecurity and violating human rights for quite a long time. But surprisingly, on the other hand, we have seen some really positive developments in Chinese law protecting personal data. For example, last year, China passed the Personal Information Protection Law. This law has been broadly based on the principles and provisions of the EU's General Data Protection Regulation. It provides, according to many analysis, provides a framework of largely high-level data privacy protection. In particular, it strengthens individual rights, for example, to consent, to give the consent to let online platforms to collect data. So individual rights to consent has been protected by this law, and the individual right to access, rectify, and erase personal information are also protected by this law. So this is another spectrum showing that while China, may infringe upon individual information in many aspects, but on the other hand, when it exercises digital sovereignty, it also protects individual rights to personal data in a very adequate way. So it seems that digital sovereignty does have this kind of double-edged nature. So now let me turn it to Anupam to talk about other instances about digital sovereignty.
Great. And I want to connect this this last slide and concept to some earlier work of mine. In a paper in 2015, I wrote about the rise of data localization across the world and noted that this data localization represented a kind of second generation of internet border controls. The first generation of internet border controls was, of course, what China invented in the form of digital sovereignty, which is protections from information flowing into a country. And this second generation of internet border controls, data localization, means that you prevent information from flowing out of a country. And what I worried about in that paper was that this maximizes control. And so, this is a way to really assert digital sovereignty, to make sure your data stays at home as well. And it gives governments increasing power, increasing surveillance power over their own citizens. So anyway, so it's a really, as Haochen said, it's a double-edged sword. It gives increasing control, but that control can also be a little bit scary. Okay. The European Union here we've seen has moved towards embracing digital sovereignty, and in fact, when European authorities talk about internet sovereignty, they are kind of some of the leaders in the world in talking about digital sovereignty. But we've seen this this isn't a new phenomenon for anyone who's studied this for a while, as we have. So as early as 2010, the government was sounding the alarm about the loss of sovereignty in the face of foreign technology firms. Now, this goes back much earlier than that. I found references to worries about this in the in 1970s and 80s. So in some other work that I'm doing right now. Francois Fillon, then Prime Minister, North Americans dominate the market, which nevertheless constitutes an absolute majority stake for the competitiveness of our economies, and even, I dare say it, for the sovereignty of our countries. The French government detailed efforts in 2013 to make France the world leader in the field of big data. And of course, we know this best through the EU's assertion of data protection law, and including its extraterritorial application of its laws, which I think are largely justified, but are complicate the scene for most of the companies operating in this space. Okay. One of our striking findings was the comparison between two kind of authoritarian states, China and Russia, and their approach to digital sovereignty. So in the early years, it turns out Russia embraced the internet and embraced essentially openness on the internet. It did not create a great firewall of Russia. Why? Because it seems it thought it was likely to prevail on the internet. It thought its computer scientists, its technology would make it a leader on the global internet. In the last handful of years, we've seen a huge turnaround of this vision. Putin has realized that the internet presents a threat to him, and has sought to centralize control, even including building essentially what can be an alternative internet, a RUNet, which could be cut off from the global internet, thereby allowing an internetworking between computers, and as critical as that is to your economy, while still being able to prevent data from coming in from outside. And one of the striking things again here is that this is in response to claims of information warfare waged by Western countries. So Russia is justifying its decision to kind of create an alternative internet on the idea of foreign interference in Russia. The worry about foreign interference is widespread. When we think about in the United States, we're typically worried about foreign interference from Russia, of which there is tremendous evidence, by the way. And Russia here is justifying its authoritarian turn over the internet on the basis of foreign interference as well. And so, we see this as, in the context of Twitter. Most recently, we've seen Google and Facebook being challenged with respect to a material that the Russian government thought was improper, which happened to support the opposition party. And Google ultimately relented, largely because of the possibility of Russia acting against its employees on the ground. This was a difficult question for any country with people on the ground. Okay. The US, on the other hand, doesn't talk about digital sovereignty. Why? Because it never had to. We always had digital sovereignty from the very start. So we never bothered to say we need digital sovereignty because we always had it. Okay. Data about Americans is typically stored in the United States because it's typically intermediated by American companies. That's not always true, of course, but it's true in a significant part. And the US government complains about digital sovereignty efforts elsewhere, and typically calling them protectionist. And so the US has complained about digital sovereignty, even though it's actually actively engaged in digital sovereignty efforts from the start. I was struck and looked in this process, when was the first FTC fine against or FTC action against an internet company? related to privacy. It turned out GeoCities in the late 1990s. So we may have had privacy enforcement at the federal level with respect to the internet before Europeans had privacy enforcement at the national or level with respect to the internet. Or rough, we had early enforcement. So in other words, we exercised it from the start. I know that doesn't mean that we had comprehensive privacy law, I get that, et cetera, which is different than the Data Protection Directive, et cetera, and national versions thereof beforehand. But we have been able to control the internet for a very long time indeed. Now, from the Global South perspective, there's been a concern that we need digital sovereignty in order to ward off what we see as a new form of what has been called data colonialism. The fear that the developing countries are now merely raw materials now in the form of data, and markets in the form of processed information for Western manufacture. And so this is a serious concern, and the question is how to respond to this concern. I think it's a fascinating problem and an important question. And what you see are some African countries and India and Brazil in particular, kind of saying, we're not sure how we feel about the global internet generally. And in India, what you've seen is concern about Twitter and some other services that are seen as censoring the ruling party, the governing party. And so the concern is, should we be allowing these services? In Nigeria, the government banned Twitter because Twitter they saw what they thought was censoring improperly the Nigerian leaders. Twitter thought the Nigerian leaders were threatening violence against a minority. So I will leave that to others to discuss further. Now, digital sovereignty is different than traditional sovereignty in a variety of ways. So I'm just going to go through this very quickly. It's always global. It's against corporations. So we're typically trying to control far-off corporations. It offers more control than traditional sovereignty in many ways because of the data gathering that's possible, because of the huge surveillance apparatus that the internet offers. I don't know how many cameras there are on my phone, in my house, for example, with devices that you may not have realized had cameras installed in them. Also at the same time, and I do a lot of trade law, it enables protectionism. And so you can use your digital sovereignty in ways that favor domestic enterprises of various sorts. And I've criticized that in a paper called Data Nationalism that I mentioned earlier about data localization measures. Okay, and then just to conclude the last portion of our paper, I should have mentioned that the paper is forthcoming in the Vanderbilt Journal of Transnational Law, which is a journal I'm excited to work with, having admired their publications over the last few decades. And we've been very happy with our Vanderbilt editors as well. So let me commend that journal to anyone considering submitting your international law pieces. So let's talk about the double-edged sword of digital sovereignty here and give some examples. NetzDG, which I cited earlier. And so many people have criticized NetzDG as giving the authorities too much power. Is NetzDG, does it go too far? Does it impinge on free expression? Um, so we have various descriptions here. I'll move just to keep it moving. Are various privacy actions justified? And let's go to. I'm going to go turn the podium back to Haochen to take us home.
Thank you, Anupam. So I'm going to talk about the double-edged nature of the digital sovereignty from the perspective of national security. So I think the TikTok case in the United States illustrate this kind of double-edged sword. In the traditional sense, national security has been sort of invoked as a legitimate legal ground for controlling, for example, certain part of the internet activities. When certain kind of internet activities threaten national security, a national government can exercise this kind of digital sovereignty power to regulate the relevant internet activities. So this has been regarded as a legitimate legal basis for exercising digital sovereignty. It's a legitimate cause. But on the other hand, you can see that when national security has been invoked as as a reason for triggering digital sovereignty, there's another kind of danger simmering recently in the recent cases. So TikTok case actually illustrates this kind of dangerous elements simmering and the national security claims. So I'm pretty sure that the audience knows TikTok very well. And in the United States, actually, TikTok is one of the most popular social media applications. And by July 2020, it actually had around 100 million users. What a miracle. But you know what? TikTok's parent company is is a Chinese company called ByteDance. Okay, so although it sounds like a foreign company operated app, it's actually controlled by a Chinese company, which is headquartered in Beijing. Okay, so in July 2020, President Trump announced that the United States was going to ban the operation of TikTok in the United States on the grounds of national security. So he first claimed that the Chinese government could rely on TikTok to secretly compile, American citizens' personal data and use them to blackmail. So then the Trump administration found a provision in a Chinese law which says that any organizations or citizens shall support, assist, or cooperate with the state intelligence work according to the law. So this law compels Chinese companies to cooperate with Chinese government's operations in relation to, for example, intelligence. So this is some evidence showing that TikTok might be collaborating with the Chinese government in doing harm to American citizens' interest in personal information. At the same time, the Trump administration also alleged that the Chinese government would use the TikTok app to censor American speech or to disseminate Chinese communist propaganda. So that's another reason targeting TikTok. So before this order was issued, actually TikTok suspended an American teenager's TikTok account. This is because the teenager cleverly used an eyelash tutorial to criticize Chinese government's treatment of Uyghur Muslim. But later on, TikTok actually apologized for doing that. It was a mistake. it was such an isolated case, but the Trump's administration just targeted this isolated case, and as I said, accused that the TikTok was actually, in their opinion, controlled by the Chinese government. So then later on, TikTok sued the Trump administration, and the U.S. court ruled in favor of TikTok, deciding that the Trump administration actually did not show sufficient evidence about TikTok's being controlled by the Chinese Communist Party, causing harm to American citizens and censoring speech on the internet. And later on, the Trump administration also exercised its digital sovereignty power to ban the operation of WeChat in United States. As you know, WeChat is another social media application developed by a Chinese company, Tencent. So this app, it's pretty much like a chatting app, right? Okay, allows people to send messages, videos, images on the internet. So again, as I said, this ban was made on the grounds of national security, quite similar to the TikTok ban. But the U.S. court again ruled that this ban on WeChat was illegal because it violates the First Amendment of the United States Constitution, which protects freedom of expression. WeChat is a public forum supporting people to express their opinions on the internet. So you can see that these two administrative bans either did not have sufficient evidence shown threat of national security, nor did it show any. Actually, the court ruled that it violate the free speech right. So you can see that if the digital sovereignty power is to be invoked for some illegitimate purposes, abuses of power might occur. So this is this is some of a range of cases showing that this kind of double-edged nature of digital sovereignty. For some countries, especially for developed countries, digital sovereignty power has been invoked to protect, for example, national security and many other national interests. But on the other hand, it can also be invoked by the party who can abuse the exercise of this kind of power. So let me turn it to Anupam.
Great. Thanks, Haochen. So we can also, just this last example that I wanted to just point out, there's a lot of concern that's often expressed about China's technology being offered up for surveillance purposes across the world through, for example, Africa. When we wrote this, we saw that this is a few months ago now that we wrote this, that this was a problem not just of African suppliers. One may recall that the Great Firewall of China was built using American technology. Cisco provided routers that allowed you to censor to do deep packet inspection. And censor things to the Chinese government. And so what we wanted to do was point out that, hey, look, we should clean house in our liberal states as well, because the NSO group, as we've seen, was offering up ways to own other people's cell phones, and was careless with that power being distributed across the world, and so giving it to lots of countries and governments that were likely to be abusing it. It had protections in place, so you couldn't target certain friendly nations, by the way, and so it had the ability to stop its technology from being used to target certain politicians that it realized it should not be targeting. So anyway, just as a kind of the complicated nature of digital sovereignty, we need to make sure that we have been kind of that when we, so partly it's also a general point that I wanted to make about the nature of the laws that we offer. I think we should be careful of how we write laws in the United States or in European nations or in other liberal democratic states, because those same laws might be used by governments that have more, that see those laws as a way to gain greater control over society, and in particular to target their political enemies. That is a concern that I think we should have more generally, and think about. So I've always thought that a kind of Kantian categorical imperative is the right approach to the internet, to think about how if we legislate for the internet, we should imagine that same rule being offered by other countries across the world. We should also remember, we in the United States should also remember our own recent escape from a wannabe despot, and be careful about what powers we give to future leaders who come in and want to be despots in the future. Okay, so I'll stop there and welcome your questions. Thanks.